Monsieur le greffier.
Mr. Registrar, kindly call the case.
Thank you and good afternoon, Your Honours. This is case number ICTY 0367T, the prosecutor versus Vojislav Šešelj.
Merci, Monsieur le greffier.
Thank you, Registrar. Today is Thursday, 5th of May 2011. Good afternoon to all the people present in and out of the courtroom, Mr. Markussen, Ms. Bierse, and the other OTP representative. Good afternoon to you, Mr. Šešelj, and to all the people assisting us. I'm going to resume with reading out my dissenting opinion. I had reached paragraph C, ordering under Article 7.1 of the statute. In paragraphs 144 and 145 of the prosecution pretrial brief, the prosecution argues, and I quote, that the accused ordered himself the crimes of persecution, murder, torture, cruel treatment, and forcible transfer in Vukovar, counts 1, 4, 8, 9, and 11. Paragraphs 15 to 18, 20 and 28 to 32 of the indictment. In ordering, I quote, not one Ustasha is to leave Vukovar alive. Testimony of witness VS 027. He also, I quote, ordered the crimes of persecution, deportation, and forcible transfer in Hrtkovci, counts 1, 10, and 11, paragraph 15 to 17, and 31 to 33 of the indictment. During meetings with associates and supporters in Vojvodina in 1991 and 1992, and implicitly in his speech in Hrtkovci on the 6th of May of 1992. And finally, that the intent of the accused to order the crimes in Vukovar and Hrtkovci can be inferred from the contents of his speeches and interviews, and from the fact that the crimes were indeed carried out later. The prosecution relied on the testimony of witnesses VS 105, 1015, VS 26, and VS 1033. With regard to the sentence in Vukovar, the above-mentioned sentence he spoke, it is challenged by the accused, and the only witness speaking about it does not appear in my eyes to be sufficiently reliable. As a result, it cannot be inferred that the accused is to be held responsible under this mode of responsibility under Article 7.1 of the statute. Regarding his speech in Hrtkovci, the question is whether what he said during the speech, as characterized by the following sentence, I quote, I am firmly convinced that you, the Serbs in Hrtkovci and the surrounding villages, you know how to remain united and live in harmony. I know that you will swiftly get rid of the Croats remaining in your village. Is this an order? That is the question. All the more so since the case law quoted by the prosecution in footnotes 488, 489, and 490 in the following cases, Kordic, Blaškić, Krstić, and Akayesu, predicates that the individual issuing the order is in a position of authority, and that the status of the accused gave him the power to issue orders. At the time, the accused had no political or military authority whatsoever. He did not have the requisite authority to issue any orders. A close scrutiny of the Chodkowski speech on the 6th May 1992 amply confirms this, inasmuch as it recalls that there is a regime in power and that there is an opposition, including the Serbian Radical Party. And he says in the speech, I quote, "We condemn the current regime both in Serbia and in this rump Yugoslavia. Furthermore, there is a blatant contradiction arising from the modes of liability. He cannot, on the one hand, be charged with issuing orders, and on the other hand, with instigating to commit, let alone committing. It can only be one or the other mode of liability. Therefore, the accused, in my view, should be acquitted of this mode of responsibility based on issuing orders or ordering." Very well. Let me move to Chapter D, committing. I believe this is the most important part in my dissenting opinion. Before I move on to this chapter, let me say this by way of introduction. On page 43791 of Exhibit P00031, the accused, when he testified in the Milosevic case, said the following, answering a question by Mr. Nice with regard to the solemn declaration, with regard to the tribunal. I am going to quote everything he said. "I am of the view that it cannot be objective and that this tribunal is intensely, utterly biased. As far as I'm concerned, I could sweep aside this type of discourse when it comes to evidence, and I could say that all this is just part of folklore, it's just something picturesque, and I could calmly wait until our final deliberations to address the key issue of the joint criminal enterprise." As a judge of this tribunal, I am part of it. And I can be of the view that the accused believes that I am biased on principle, and that I am not going to go into the issue and the merits of the issue, which is joint criminal enterprise as addressed in paragraph 6 of the indictment. Well, I'm going to do it. And I am by putting in the balance the point of view of the prosecution and that of the defense in order to reach a provisional conclusion at this stage of the proceedings. This is an utterly complex legal matter, and Much to my regret, I cannot address all the facets of it because this is an oral type of proceeding. However, and nevertheless, I'm going to devote 20 pages to the issue. In other words, a little under 1/3 of my dissenting opinion. Very well. Let us speak to the issue of the accused alleged responsibility as part of as a participant in the joint criminal enterprise. Paragraph 6 of the indictment states as follows. Vojislav Šešelj participated in a joint criminal enterprise. The purpose of this joint criminal enterprise was the permanent forcible removal through the commission of crimes in violation of Articles 3 and 5 of the Statute of the Tribunal of a majority of the Croat, Muslim and other non-Serb populations from approximately 1/3 of the territory of the Republic of Croatia and large parts of Bosnia and Herzegovina and from parts of Vojvodina in the Republic of Serbia, in order to make these areas part of a new Serb-dominated state. As to paragraph 8, it lists the participants in this joint criminal enterprise. They have to be named. This is important. Slobodan Milošević, General Veljko Kadijević, General Blagoje Adžić, Colonel Ratko Mladić, Radmilo Bogdanović, Jovica Stanisic, Franko Simatović, alias aka Frankie, Radovan Stojicic, aka Baja, Milan Martic, Goran Hadžić, Milan Babic, Radovan Karadzic, Momčilo Krajšnik, Biljana Plavčić, Željko Raznjatović, aka Arkan, and other political figures of the former Yugoslavia, from the Republic of Montenegro and of the Bosnian and Croatian Serb leaders or leadership. Equally, there were other participants. They included Serb forces collectively defined as members of the Yugoslav People's Army, JNA, later the Yugoslav Army, VJ, the newly formed Serb Territorial Defense of Croatia and of BiH, the Army of the Republika Srpska Krajina, SVK, and the Army of the Republika Srpska, VRS, and the TOs of Serbia and of Montenegro, Local Serb, Republic of Serbia, and Republika Srpska police forces, the police forces in Krajina and RSK, commonly referred to as Martić's police, Martićevci, SAO Krajina Police or SAO Krajina Militia, and members of Serbian, Montenegrin, Bosnian and Croatian Serb paramilitary forces and volunteer units, including Chetniks or Šešeljevci, translated as Šešelj's men. In support of the JCE, apart from the evidence they quoted in their oral submission, the prosecution refers in paragraph 4 of the indictment to the participation of the accused in the JCE by breaking it down in 3 categories. I am going to list them. Firstly, the accused allegedly used his power as a politician to promote in the media or through the media his plan of creating a greater Serbia by violent means. Secondly, as the SRS president and as the chief of the SCP, he allegedly supervised the recruitment, indoctrination, funding, formation, coordination, supply, and assignment of volunteer units, which often gave rise to forcible displacement of non-Serbs living in the targeted territories. Thirdly, the accused allegedly largely contributed to the implementation of the JCE by crimes of persecutions through hate speeches in Vukovar, Zvornik, Hrtkovci, and to crimes of deportation and inhumane acts, forcible transfer in Hrtkovci. In support of the alleged JCE, the following documents were mentioned in the prosecution pretrial brief: the Tomic report, exhibits P255, P1200, P32, P1176, P34, P35, P1196, P1197, P40, P1185, P1176, P1196, P1220, P1186, P163, P34, P35, P644, P1003, P59, P513, P221, and P915. So for reading out all these exhibit numbers, but I told you that I was really to look into, in a detailed fashion, into the prosecution case. I had to do so. Equally, the prosecution mainly refers to the testimony of the following witnesses: VS14, VS26, VS1104, VS1133, VS007, VS010, VS011, VS017, VS027, VS038, VS1008, and VS1136. Very well. So this is the entire prosecution case, as stated above, based on testimony and documents. At this stage of the proceedings, at the 98 bis stage of the proceedings, there's no need to dwell at length as to the applicable law in this case, because during the prosecution case, there are no witnesses, no expert witnesses, or even less amici curiae dealing with legal matters that have to be dealt with only at the time of the final deliberation. However, I have to briefly address the notion of joint criminal enterprise as introduced by the appeals judgment in the Tadic case. In this regard, the Tadic appeals chamber, in paragraph 227, regarding the actus reus, said the following. Let me read this to inform everybody. Little I, a plurality of accused. but they don't have to be part of a military or administrative structure, as clearly shown of the Kurt Goebel and the Essen cases. Secondly, the existence of a common design or objective, which is to commit one of the crimes in the statute or to imply its commission. This plan, design, or objective does not need to have been prepared or expressed in a prior fashion. It can be manifested by chance and can be inferred from the fact that several individuals act together in order to carry out a joint criminal enterprise. Thirdly, participation of the accused in the common design involving the perpetration of one of the crimes provided for in the statute. This participation need not involve commission of a specific crime under one of those provisions: murder, extermination, torture, rape, etc., but may take the form of assistance in or contribution to the execution of the common plan or purpose. With regard to the mens rea, the appeals chamber stated that it may differ according to the category of common design under consideration. Well, there are three categories. Let me name them all. The first category of cases requires the intent to perpetrate a specific crime, this intent being shared by all the co-perpetrators. For the second category, the accused must have personal knowledge of the system of ill treatment, whether proven by express testimony or inferred from the accused's position of authority, as well as the intent to further this concerted system of ill treatment. The third category, which is the extended category, requires the intent to participate and to further the criminal activity or the criminal purpose of a group, and to contribute to the joint criminal enterprise or, in any event, to the commission of a crime by the group. In addition, responsibility for a crime other than the one agreed upon in the common plan arises only if, in the circumstances of the case, little I, it was foreseeable that such crime might be perpetrated by one or other members of the group, and to little I, the accused willingly took that risk. This case law is far from being accepted unanimously. It is indeed challenged within the very tribunal by various judges. For instance, by Judge Schomburg in his individual opinion regarding the criminal liability of Milan Martic. To make it short, I must remind you that there is no reference whatsoever to joint criminal enterprise in the statute of this tribunal. Furthermore, the UN General Secretary, in his report of 3rd of May 1993 to the Security Council, said the following. I am going to quote the entire intervention. The question, however, arises whether a legal entity, an association, or an organization may be regarded as such as perpetrator of a crime, the members of which would be, for that very and only ground, submitted to the jurisdiction of an international tribunal. The General Secretary is of the view that this concept should not be adopted by the International Tribunal. criminal acts listed in the statute were carried out by physical individuals, and they would come under the jurisdiction of the International Tribunal, irrespective of whether they belong to a group or not. This is part of paragraph 51 of the General Secretary's report. Let me add that there cannot be any collective responsibility, as was stated by the Nuremberg Tribunal. I quote, "These are human beings. They are not abstract concepts. They are men who commit crimes that must be punished in international law." I also note that the mention of collective responsibility is not in keeping with the mission of this tribunal, which is to encourage peace and reconciliation in the territory of the former Yugoslavia. In order to complete this provisional survey, I have to refer to a recent decision of the preliminary chamber of the extraordinary chambers of the Cambodian tribunals, who, whilst accepting the use of JCE 1 and 2, dismissed JCE 3, holding that this mode had no foundation in customary international law at the times of the indictment.
Il suffit de lire le
You just have to read paragraph 83 of this decision. As far as at the stage where we are now in this 98 bis procedure, without finalizing my position as to the JCE theory, I will integrate it, however, in order to examine whether the evidence adduced so far would make it possible to conclude that this alleged JCE did exist. Now, to try and characterize this JCE, the judge must, since it has no formal documents at hand to establish the existence of this common purpose, must go and fish for clues. And among these clues or indicia, I must mention for your information those who were mentioned in one of the latest judgments of this tribunal in the Georgievich case. And this is a list of these indicia. Demographics. Secondly, abusive use of force by Serbian forces in violation to the October 1998 agreements. Motivations for the crimes. Any coordinated management of MOOP and VJ units. A disproportionate use of force in anti-terrorist actions. The systematic control of IDs and registration plates for the vehicles of Kosovo Albanians, and all efforts deployed to hide the crimes committed against the Albanian civilians in Kosovo. As you can see, fishing for clues can prove to be very unsuccessful. In this case, for example, because at first sight, the only clues that could be taken on board so far are the demographics and the motivation of crimes. A reasonable judge could not conclude, therefore, to the existence of a project bringing together all the people mentioned. Even though, according to the prosecution, the only inference is that a common purpose connected and brought together all these people. The evidence adduced by the prosecution do not formally go in this direction. It is obvious that the members of a JCE must have some kind of connection among themselves, either coming from professional meetings, from gatherings, from papers written jointly, from joint stances at one point in time, from belonging to the same party, or from belonging to the same government. It would be paradoxical to state that they are members of this JCE automatically, just because of their beliefs, of their ethnicity, of their religion, of what they think. And how, if a judge can analyze the most intimate thoughts of an individual. Therefore, as far as I'm concerned, I believe what is important is to have intangible elements that could establish this connection between all these members. And the OTP didn't miss this because they said that the time frame of this joint criminal enterprise would run from August 1st, 1991 to September 1993. It's quite interesting, actually, to look into why this month of September was determined. Prosecution, in paragraph 8 of the indictment, says, and I quote, "The aforesaid joint criminal enterprise came into existence before 1st August 1991 and continued at least until December 95. Period. Vojislav Šešelj participated in the joint criminal enterprise until September 1993, comma, when he had a conflict with Slobodan Milosevic," end of quote. So the prosecution recognizes that there is a need to establish this connection. Because obviously, after the conflict with Slobodan Milosevic, there was no longer any common purpose. And in a very inconsistent way, in Radovan Karadzic's indictment, which is in the public domain, the time frame runs till December 95 and mentions Vojislav Šešelj as belonging continuously to this JCE. The prosecution explained its position in its motion of May 17, 2010, in view of tendering bar-tabled evidence. For the prosecution, this evidence was relevant because they deal with the JCE, the accused mens rea, and his contribution to the joint criminal enterprise. However, the prosecution developed its point of view at length, saying that with the rise of Serbian nationalism during the carving out of former Yugoslavia, the accused became the ally of Slobodan Milosevic and of other Serbian leaders, and that together they pursued this objective, which was to unite all Serbians within a single state, which the accused called Greater Serbia. The creation of this Greater Serbia resulting in a forcible transfer of non-Serb population and the commission of other crimes against this non-Serb population. In this motion, these are the exhibits mentioned by the prosecution: P1321, P1167, P1169, P1170, P1263, P1264, P1175, P1301, P1206, P1388, and P1364. For the prosecution, the accused adopted the ideology advocated by the Serbian Cultural Club and the Serbian Chetnik movement, P1170 and P1172. The accused Šešelj was appointed voivoda, P1170, P1322, P1180. According to the prosecution, the JCE was created in February 1991. In 1990, the accused had created the SCP and tried to register this SCP, but this was unsuccessful. P1264. He then founded the SRS in February 1991, which at the time was recognized as a political party, P1265. According to the prosecution, the accused admitted that his party understood the struggle for the defense of Serbian national interests as an opening door to have cooperation with the SPS of Slobodan Milosevic and the SDS. Even though prosecution does quote the following sentence, and I quote, "We disagree on everything else, but we must cooperate to defend Serbian identity. We are waging a common struggle, and nothing should come to divide us on this issue." P1204. End of quote. To support this, prosecution mainly refers to documents P1282, P1187, P1233, P1312, P1243, P1251, P1252, and P1327. Out of all this evidence, the prosecutor had tendered the testimony of the accused in the Milosevic case. This is document P00031. According to the prosecution, this qualifies a JCE. It's a very long document, more than 1,600 pages. I scrutinized it word by word. And the review of this transcript, which goes from pages 42678 to 44370, shows that the accused Šešelj did not know a number of members of this joint criminal enterprise. Simatovic, for example, I'll come back to this, or only had very infrequent contacts with others, for example, Babic. And regarding Milosevic, he only met him in April 1992, which is long after this alleged JCE would have come into being. It is true that Šešelj's statements made under oath could, after all, be false. It could only provide us with part of the truth. However, during its cross-examination, the prosecution did not rebut these statements. So, as things stand, what Šešelj, the witness Šešelj, said under oath in the Milosevic case could be taken on board by a reasonable judge as being quite relevant and probative. A few examples. Page 43932. The accused said, when he was in the witness stand as a witness, and I quote, "I insist on the fact that Franko Simatovic is somebody that I have never met in my entire life." Now, regarding Slobodan Milosevic and his connections with him, he said on page 43943, I quote, "In May 1992, I started having meetings with Milosevic in a more regular fashion. On page 44333, this is what he says. It was impossible to design any connection between us because up until April 1992, we didn't know each other at all. Page 44100. And I'm quoting the witness again. You want me to tell you what the relationship was between Mr. Milosevic and Mr. Hadzic? Hadzic being the famous accused at large. Well, I've been in conflict with Mr. Hadzic since 1991. And I've only made very negative statements as far as he's concerned. Then Judge Bonamy intervenes and puts the following question to the witness. I quote, "Didn't you say that it is totally out of the question that Mr. Hadzic may be involved in an JCE with the accused?" The accused being Slobodan Milosevic here. Answer of Vojislav Šešelj. I said that it was impossible that he would have participated with me in anything because there's always been a conflict between the both of us. The prosecution, failing to adduce any relevant evidence regarding the members of this JCE, does not prove that these people had a connection in the meaning of the case law given by the appeals chamber and mentioned earlier, or that they shared the same intent. Therefore, what would have been needed would be evidence that would establish that the members of this JCE had the same intent as the accused to deport non-Serbs, notably to make sure that Muslims and Croats leave forever about 1/3 of the territory of the Republic of Croatia, as well as large areas of the Republic of Bosnia-Herzegovina and some areas of Vojvodina, in order to integrate these regions in a new state that would be dominated by Serbs. I will now go into further detail. Therefore, the final goal of the JCE, according to the prosecution, would be to integrate these regions in a new state dominated by Serbs. This being the case, the question any reasonable judge should have is to know what exactly are the boundaries of this greater Serbia, as mentioned in paragraph 9 of the indictment. This says that the accused, and I quote, propagated a policy of united all Serbian lands in a homogeneous Serbian state. He defined the so-called Karlovac-Ođulin-Karlovac-Virovića line as the western border of this new Serbian state, which he called Greater Serbia, and which included Serbia, Montenegro, Macedonia, and considerable parts of Croatia and Bosnia-Herzegovina. In the pretrial brief, in the prosecution's pretrial brief, it is also said that Vojislav Šešelj greatly contributed to the joint criminal enterprise by playing the role of leading propagandist of creation through violence of a greater Serbia, a unified state dominated by Serbs. In the middle of the 1990s, Vojislav Šešelj relentlessly called for the creation of a Serbian state corresponding to the present borders of the republics of Serbia and Montenegro and to a major part of Croatia, Macedonia, and Bosnia-Herzegovina. To support this, the prosecution mainly refers to the following exhibits: P1321, P1170, P1169, P150, P171, P1172, P1173, and P39. It's important to note that the articles, and the interviews of the accused were spread over time. And the prosecution itself made a difference in its pretrial brief between several types of speech.